which mandate they are coming before this court.
No, don't give him answers. Don't give him answers.
And these are witness.
These are witness now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No. Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of the RDR.
Please read for me so I can answer.
No, you read it. I did write it. Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1 and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in your affidavit talked the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. That is simple.
I have indicated the sections. 6.1, 7.
Tell the court. Just tell the court.
Yeah, hold on. I have indicated section 6A, 7.1 and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that mandate? The IPOA Act. Just read to the court those sections for the benefit of the whole world. We don't work for IPOA.
Your Honor, because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just give us the...
This age of selective amnesia when it is corner. It is there. On any phone. Just read it. Read the section. 6, you read.
Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA. And the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police, specifically, that's all. My question is specific.
Your Honor, this
JV allowed the witness to read.
This is a,
Sorry, Your Honor.
before you even say anything, this is a question that has been put to this witness. It is about what he has said in his affidavit. He is being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him. Let him answer.
Yes. Yes, Your Honor, I just wanted to indicate. Section 6, as we refer to in the affidavit, the witness has been asked to read, he has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit, but we would be guided.
So let him answer. If it falls under the ambit of that section 6, let me just say...
That's right, that's right. That's right, yes, that's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
in police custody.
It's not you to set the question. I've asked you my question. You can't set a question and answer yourself.
Yes.
If it's not there, it's not there.
The question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's
Yes. And custody.
That's what I'm saying. The court has gotten what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later moved at the Gata police station by OB 50-13-6 of 25 at 18:05 hours.
The DCI officers arrested him at what time, according to your there?
Say around 3.
You read exactly what you said.
I've not indicated the time.
That's what I'm asking.
Yes.
It is not indicated when the DCI officers arrested him.
Yes.
Where did they arrest him?
At the DCI headquarters.
And the nota Eldoret confirmed that the accused was not arrested at Eldoret, the respondent.
According to the officers who handed over me to Mr. Talaam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my department.
I'm saying what is in social media is that the respondent
Your
was
Honor, I
arrested.
can
in
only
Eldoret.
answer what is in this affidavit.
Sorry, Your Honor.
let's not digress to those issues.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you're not aware, you're not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside
All
the
right.
affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Kenton. Were you aware of that?
If you say so.
And the DCI authorized his officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please,
You don't need to answer.
Please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've
I've
only put it to you. I've not asked you the question.
Is it in my affidavit?
I'm
The
putting
question
it
I'm
to you.
asking to you is it in my affidavit?
For the
Answer is
benefit
no.
of the court, I'm putting to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my
I've not asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Talaam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is he?
Is that my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question. I'm only putting it to you
Please
for
ask
knowledge
me.
purposes. So now, if those are the facts, Look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
No, cool your tail. It's a long day.
No, it's a long day, yeah?
Since it's rich, it can bring water for both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA.
The court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matters we have is the one given by the witness before court.
The only way to prove a falsehoods is by bringing facts that are truth. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
Sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that is telling us is, I put it to you. And we hope it does not go to evidence.
Counsel, just to allay your fears.
Yes.
The evidence that I'm documenting is from you.
That's right. Thank you very
Not
much.
from Mr. Danstan.
Thank you.
Because as you put it rightly, he's not giving evidence.
Correct.
I'm not-
He knows the procedure.
Thank
That's
you.
why.
He's a teacher of the law.
Yes, and that's why I told you, now he is mature to be a judge of the high. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor?
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
The respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command of the police station?
As an OCS,
No, I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty and in command?
Your Honor, what I would ask is that you are the presiding magistrate here. Do you have the power over this one? I mean, once you are an OCS, you have got the power over that station. Come on, Counsel.
We have agreed that you don't. You are looking for me. Let me put it fine. And let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
And I've asked a simple question.
Yes.
Among the annexures, have you produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident, he was the officer commanding station at Central Police Station, in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear, you have not attached. All that's what you are looking for. It's not attached there.
And maybe to answer your question, any other attachment you might ask is not there, save for the OB extract of the
Just don't go.
relax.
And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question. And I put it.
Why are you putting in the first
No,
place?
really went to law school. I know. You see, we have our own legal view. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the OCS left the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has heard it. So. Let's go. Paragraph 15. On the question of him likely to plan. You there?
Yes.
We have agreed there is no any material presented.
Yes, nothing
Thank you.
attached.
Let's proceed. Paragraph 10.
We go back.
Oh, I asked you paragraph 15.
Yes.
I'm going to paragraph 16, sorry. Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18,
No material attached.
no material attack. Paragraph 17, I've gone back because there's a question I want to ask.
Please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Start on off. Because I was there yesterday myself. It's not true that the scene of crime has been released to the police. Is it still a scene of crime or it is non-operational police station?
That question is not, it's not in my evidence.
You've run very fast. You do not lie that is. So you cannot, there's no material to show that.
Nothing aside, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same?
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. Which this is a lawyer, he knows High Court decision.
What part of the decision?
Give the court that decision.
In the Titus Gamau case, 2020. It's the first one coined by the judge who was dealing with whatever.
And I remind you, Cliff is the one who argued that matter.
Yes.
He's here. He'll face you over that matter. He's the one who argued that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him in paragraph 23?
That we have to record the critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required.
There is a submission. I've not asked any question. I've only told you to look at that section.
It's a matter of evidence on the facts. It's an affidavit of evidence. So let's get into the facts of it.
After I've asked the question, then that is when an inference can be done, whether it's a question of law or a question of fact. I've not asked what. I've only told you look at section 380.
Your Honor, just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit.
True.
There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are pleadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
Yeah, I just always told you to.
Let's not configure it. Let's leave it an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I'm asking, and I ask a question of law, then the court can stop.
Okay, proceed.
Let him have that. Let him look at what I'm
Once
doing.
you point to the law, then
No.
And that exactly is our objection, that we can't
7 and 25 of the IPOA Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang by the police custody at Central Police Station within Nairobi. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Yeah. All that the witness is saying has been said. Can only adopt. Because unless there's any other crucial information.
That's another one. That's another one. Yes.
Yes.
That's actually not that. They can proceed to examine all the.
Thank you. Your Honor, I'll be asking brief. Three. Police Act
IPOA.
under IPOA Act. And under IPOA Act, is it true that you have still arresting powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPOA Act and Section 7 of the IPOA Regulation Act actually gives me the powers, privileges, and immunities of police officers.
So section 7. Which section?
For Section 7 of the IPOA Act and Section 7 of the IPOA Regulation Act.
Gives you the powers as that of a police officer.
Yes, sir.
And in this matter, you are now actively participating pursuant to those provisions as an investigator?
Yes, sir.
Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach when we became lawyers. Some people are mad about that.
You are not aware. Thank you. So you have not, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press
No,
conferences.
leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it? Yes. Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that you have presented before court?
That's not in my life.
No, you have in your affidavit. Not
I'm
everybody.
saying,
Yes.
the answer that you're looking for is not in my affidavit.
No, I am asking a very straightforward question likely to attract a yes or no. I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all from me. Thank you.
The two.
I'm actually going to very limited time in the form of 2 minutes.
2 minutes and Sophie 2 minutes.
And I can do 1.5
She's the only
minutes,
queen.
depending on what you want.